because I love to work with school districts. So there's a lot of school districts here and therapists also from all over Texas. And we're just so happy to host this with Eric. And we are super happy to have Dr. Lerman here with us today because he was one of our speakers at our series for In the Hospital. Unfortunately, we're out of the hospital right now, but he has so graciously agreed to come and help us out here today. And I know everyone is super excited to hear all about ethics. And yay, I'm excited. So please, Dr. Lerman, share with us, tell us about yourself, and anytime you'd like to start, go on ahead.
Okay, well, it's a good time to start now, I guess.
Okay.
Thank you, Suzy. The interesting part of doing these kind of presentations is that it's comfortable because I'm in my office doing it. It's uncomfortable because I cannot see any of you other than Suzy and Eric. And when I do these kind of presentations, I connect with people. The energy that's there usually spurs me on. I get more creative. I lose track of my notes and don't seem to miss them at all. And it tends to make for a really, much more lively kind of presentation. And when we first talked about doing ethics, I'm thinking to myself, out of all the topics in the world we can present on mental health, by far the most boring thing that most people want to avoid like the plague is talking about ethics. So, going through regulations and statutes and laws and standards of practice and all that kind of stuff. I don't find particularly interesting most of the time. And I will avoid it like the plague if I have the ability to do that until, it comes time to renew my license. And I'm going, oh my goodness, I need credits. And the strange thing about the state, at least here in Texas, is that at one time, presenters used to be able to get credit for CEUs by presenting. And that was taken away. I'm not sure which year that happened, but it dawned on me that I can't get credit for teaching courses anymore myself. So I have to go to other people's classes. And ethics is just not something that most people want to sign up for unless, like, Suzy comes along and says, hey, IntraCare is going to do this and it's free. And you can sit in your house, you can actually watch this and take advantage of it. So my job is not to really entertain you, but hopefully my sense of humor will kind of carry this through. I do have one, unfortunately, technology thing that happened to me last night. I did have a bit of a PowerPoint presentation I was going to use to complement my voice. Unfortunately, the machine died last night, and I don't have the technology understanding to know whether it was the power cord that went out or the projector unit itself. So all those beautiful PowerPoint things are in the machine. Well, it's on my computer, but they will not be broadcast out. So if you would like a copy of that, send me an email. I'll be glad to make copies of it and send it off to you if you want to get it that way. So I just want to put that little caveat at the beginning so that you realize that me talking to you is not intended to bore you for the next 2 hours, that there really was a complimentary thing that was supposed to go in with this educational experience. And because of that, I'm going to alter my presentation a little bit because I really don't want to talk at people, especially the ones I can't see. And I understand there's like 300 some odd of you out there right now, which is absolutely spectacular from my end of it. But I want to open up the questioning stuff. So as we're talking, if you have questions, put them into the chat thing. We don't have the ability to communicate verbally with each other right now because we don't have that kind of a format here. But write out the questions, send them into this chat box thing. And between Eric and Suzy, they will get the questions to me. I'm more than glad to stop halfway in the middle of a sentence if I'm getting feedback from folks, and I'll be glad to entertain you and answer the questions as best I can. I want you to know I am not an attorney. There are some LPCs out there that actually are attorneys, and they can do brilliant jobs presenting legal issues related to ethics and what we do professionally. I have been in the field for like 38 years, though. And granted, the experience by itself doesn't make me an expert, but I have learned a lot of things about ethics over the years. Thank God I've never been sued because of an ethical issue. I've been in Austin a few times to kind of experience what that's like when there's, charges that have been brought up on people and, behavioral things that shouldn't have taken place. I was raised in my graduate program from the University of Wisconsin to believe that the worst thing that any mental health person could possibly do with a client was to have sex with them. And that was the issue that was pounded into our heads. As a graduate student, as a young, fledgling person in the field, teaching at the university, you do not have sex with your clients or your students or your interns. And that was ethics. That was my ethics training. And that went on for years. That would be the first thing that everybody would talk about, is how not to have a personal relationship with your clients. It dawned on me that in our specific area of mental health, that is by far one of the least issues as far as frequency why people file complaints. Is that for the most part, we are not having sex with our clients, not the way some other mental health folks have had amazing reputations for doing and been thrown out of their professions for having done that, stuff. Our biggest hang up is not about the relationships that way. Our biggest hang up is how we keep track of our records and what we do with those records. It's a confidentiality issue more than anything else. And 94, 95% of all the complaints that go into Austin are because of either record keeping or the lack of, the inability for the patient, client, or however they're defined, to access their information, or their parents to access the information. That's by far the number one reason why folks get in trouble. And it becomes the most unbelievably awful thing to have to deal with, because it's so simple. Maintaining records is not a difficult thing. You can put them up in the clouds now. You don't have to keep hard copies of them anymore, but you got to be able to access them. And when the client wants them, they have access to it in some capacity. So what we're going to do, hopefully, is to go through that part of our state regulation. I'm not going to do the national ones, the U.S. ones on drug and alcohol abuse kind of stuff, because they have their own kind of guidelines for record keeping. It's a little bit different than Texas's, but Texas acknowledges the federal ones, and we have to comply with those as well. So what I'm going to talk about specifically is Section 611, which is the thing that hangs people up big time, because it talks about records, confidentiality, who has access, who should have access, who can have access, and what all those legal kind of things get thrown in there. I'm not going to deal specifically with a lot of legal stuff, but I am going to deal with the statutes, so you get a better understanding of what that's all about. The other thing I'm going to touch on is the issue of teletherapy, because that's not contained anywhere. It's being worked on now in Austin, thank God, finally. But it's not something that 611 talks about as far as record keeping. And what we have to be able to do is understand that the teletherapy stuff that a lot of us are engaged in right now, because we have to be, basically because of COVID-19, we are doing so in some ways flying by the seat of our pants, because we don't have a firm set of rules governing what we're supposed to be doing. There's a lot of innuendo messaging. There's a lot of use your own discretion messaging. There's a lot of indirect kind of things that we're supposed to be following, but we don't have a specific code of 14 points of what to do for telemarketing that clearly spells out what we are and what we're not supposed to be doing. Now, that's according to the state. Now, there are professional organizations like the American Counseling Association, the American Psych Association, even the state counseling association, that is now taking a much more aggressive position with the issue of teletherapy. But what I can tell you is that, unlike the psychology folks who have been busting their butts trying to get reciprocity across the country, we still do not have reciprocity, at least as of midnight, last time I checked. Texas has been working with surrounding states, but there's nothing formally in place. And the informal stuff basically means, my understanding of it, and you all are welcome if you have more information than I do, but if you were to work with a client from Louisiana, Oklahoma, or New Mexico on a teletherapy process, it is very, very unlikely that anybody will file a complaint against you. Now, it's not to say it can't happen or that it won't happen, but it's so ambiguous right now in terms of what's happening with the immediate surrounding states that you're relatively safe to do it. Now, the caution is that I would have clients sign a release letting me know that they are out of the state of Texas and that we are providing service to them. And that based on that, the value of the service is going to outweigh whether there's a regulation or a restriction that says we shouldn't do it. Now, that may not even be admissible in a court of law. I'm not sure. But what I do want to do is get their consent, so at least they know that there could be a restriction against it. But in all likelihood, it would never be taken anywhere. And I doubt seriously that our state board is even want to be involved with it. The place where we're more likely to run into it is other states outside of the immediate surrounding. If they were to understand that people from Texas, licensed people in Texas, are doing mental health therapy or counseling or evaluations with people in other states, that are not quite as willing to allow outside mental health folks to be involved, even through teletherapy. The obvious question that I always raise is, is there a difference between doing teletherapy with somebody in Houston, which is where I am, versus doing teletherapy with somebody in Bangor, Maine, or in Honolulu, or some other place? Because the therapy is still therapy. There may be some regional differences that we should be sensitized to if we're working with clients from different places. But beyond that awareness, I fail to see where the difference is between doing therapy in one location versus doing therapy in another location, especially if the client's soliciting us to do it. It's kind of a strange kind of situation we're running into. My real desire, and I've communicated this directly to the national, counseling folks, is to go after this stuff. There's no reason why reciprocity should not exist, especially with COVID the way it is, where people are reaching out. People are in desperate need for mental health services. And we're getting it from everywhere. We're getting it from schools. We're getting it from church organizations. We're getting it from even public mental health facilities that just cannot provide the kind of service that the client base, our population, is needing. So I can't go too much further with the issue of the teletherapy beyond just letting you know that we don't formally have reciprocity. And yet, there's obviously an enormous need out there for it. So my caution to you is, if you're going to do it, then do it. But make sure that you're covering yourself as best you possibly can. And if you have any questions about, whether it's an okay thing or not, check with your malpractice liability folks, just to make sure that you're getting, a legal opinion, if that's something that you're wanting. Okay, so let's move on from that. If you have questions about it, please send them in, and we'll see what we can do to kind of muddle through that area together. So let's go into chapter 611. I don't know how familiar you all are with this. I usually do kind of a survey before I start launching into this stuff, because it helps me as a presenter to actually be able to identify what kind of a knowledge base we're dealing with, or what kind of a new base we're dealing with, because I know there's a lot of new folks out there that finally got their recognition to become LPCs. I have one of my former interns who actually completed everything that she needed back in beginning of December, and then it took her 6 weeks before she finally got notice from Austin that she was in fact an LPC and no longer an LPCI. I have another LPCI that I'm working with right now, who's now an LPCA. That unfortunately it took her like 8 weeks, to finally get the paperwork out of Austin. There's a bottleneck there. Any of you who have dealt with Austin recently with our board, I'm sure you've experienced it. I have no way of intervening into that process or advising you about how to cut through some of that nonsense. All I can tell you is that it is a bottleneck right now. And part of it's growing pains, because recently, within the last 2 years, all of the mental health folks have all been lumped together under one roof now for the first time ever. The LPC stuff has been around since 1982, I believe. My first licensing as an LPC was in 1983, and it was brand new stuff then. And we were with cosmetology folks, we were with massage therapy people, and there are a couple of other groups of professional organizations that are either regulated, licensed, or certified by the state, and we were all grouped together. We had nothing to do with clinical social workers. We had nothing to do with psychologists. And then, a couple of years ago, people started to say, well, this doesn't make a whole lot of sense. Why don't we unify all the mental health people under one flag? Which made some sense, although the psychiatrists are still not part of our group. I probably never will be, because they're physicians, so they don't want to be part of us. But regardless of that point, what we are dealing with is really an awareness that we now have an opportunity to start promoting mental health, that the state is concerned protecting citizens, which is really why we have these regulations. They're not really intended for our benefit as the professionals. They are intended to protect them, which is why we get into conflict sometime with the board, because the board, even though they're made up of LPCs, and I think there's one liaison that's appointed to the board, the folks that are on that board are not there to represent us. They are there to represent the public, and in some cases against us if the public files complaints against us. So the process of educating their licensing actually includes ethics standpoint is that first reality that the board is not there to represent our ethical issues. They're there to protect the public to maybe following ethical behavior. And that is a different perceptual awareness than what a lot of people typically assume. So when you call the board up with a question, an ethical question, they may not answer it. And that would be a posture that I experienced personally several times over the years when I've had a question that I didn't have a ready-made answer for, and I couldn't go to the statutes and find a specific, something that addresses it specifically. And I would call them up and I would ask, thinking I would get an answer that would make some sense to me. And invariably what I would get would be a response that, your ethical guidelines are followed through the American Counseling Association or the social workers group of ethical things, or, AMFT, whatever it was, but it wasn't the state. The state's job is not to interpret ethics unless it's to protect the public. So it's one of those awareness things that I throw out there whenever I do presentations about ethical stuff. It's not that the state is filled with bad people, but their purpose is not to look out for our interest. Okay, that's what our professional associations are intended to do. So when you have questions about your own behavior, whether something you are doing may or may not be in line, you don't really want to call the state to get that answer, because they're not going to look out for your interest. The person to call or people to call would be those individuals that are representing you on your malpractice, your liability insurance folks, because those people do have a legal understanding, and their role is to protect you. And if you don't have coverage, I would highly encourage you to get it. It's almost impossible, not totally impossible, with a state institution or a private mental health facility, whether it's an inpatient program or an outpatient program. School districts pretty much mandate that you have to have your own personal coverage. So if there's, for some reason, you don't have coverage, or perhaps you're coming out of a university setting where it wasn't mandated, as a student, graduate student, and now you're going into either a private practice setting or any other kind of setting, really, you need your own coverage, because that is going to be your voice. Should anything come up where somebody's questioning something you've done, or you have questions about a specific issue that you want to deal with from an ethical standpoint. So with that in mind, what we're going to do is to talk about how the state looks at the issues of confidentiality and reporting. Because again, it's not about our interest, it's about the public's interest. So when they talk about a person who is being consulted for mental health, they're talking about a child or an adult, they refer to it in 611 as a patient. They don't refer to clients in 611, and that's because 611 was really intended for physicians. And then it was extended to include mental health people. I don't know if it was just an afterthought or whether people said, hey, what about the mental health folks? And they threw it in. So the wording that's in consistently through 611 is about patients, not about clients. And they define it as somebody who's receiving service, somebody that diagnosed, receives an evaluation or some kind of for a mental or emotional condition or disorder, include alcoholism, drug addiction. So that's how they define what a patient is. Now, the entire rest of 611 talks about the rights of a patient, and that defines what the role of the mental health person is in order to satisfy the right of that person. So if that is a confusing thing for folks, which I know it can be, because we're making the assumption that these rules are made for us, but they're made for us in respect to the client, because it's the client's rights that the state talks about, not ours. Okay, we don't have a right of confidentiality. It is the client's right. Okay, we don't have the right to withhold records unless our action on behalf of the client is to protect the client from something that could happen to them as a result of releasing the records, which would be in their non-best interest, or something bad could happen to them. And we'll talk a little bit about some of the things that we can do to protect records. But again, it's not our records we're protecting, it's the client's. And it's important to keep that awareness really stuck in your mind. Otherwise, the confusion that can come out of that can get you in trouble. Because even though we keep the records in our place, it's not ours. And technically, the records don't belong to us. I mean, we pay for the paper, we pay for the folders, we pay for the space in the sky. However, we're keeping these records. We make the assumption, unfortunately, a lot of us do, most of us do, that the records are our records. And how dare you do anything with our records? We even pay insurance to maintain the sanctity and the secrecy and the privacy of these records. And they're not ours. According to the state, they belong to the client. Our duty is to safeguard them so that in the event that the client should need them for any particular reason, we can make them available, which we are honor bound to do, with a few exceptions where we do have the right to protect them against exposure. So the right of confidentiality is not ours, it is the client's. Or if the client is a minor, it belongs to the parents. And keep in mind that 611 does not differentiate a custodial parent from a non-custodial parent. It doesn't differentiate whether, because of a divorce action, one parent should have access to records or not. The state just puts it out there that parents have the right to examine records. And there have been numerous cases, and this is where we get into a lot of conflicted stuff when we're dealing with divorced issues, where we're dealing with blended family issues, and the non-interactive parent is either upset at the fact that they're having to pay for the psychological or the counseling services that are being provided to the child. And they don't seem to have any access to understanding what's going on. So what they want to do is look at the records. Well, according to 611, they have a right to do that unless it's specifically banned because of a history of whatever. It could be child abuse or some other activity or abandonment issues that would clearly stand up in court. Because what we're dealing with, again, is that the records don't belong to us. We guard them, basically. So what we want to be able to do is be real clear about what that is. And that, I'm going to go through that, some of the actual specific citations in 611, so you get an understanding as to what this is, because this is where we get hung up on. This is the bulk, vast majority. I mean, this is like number one in the state of Texas, and actually it's the number one in every state of the country right now, as to why professional mental health people get in trouble with their states. It's because of the misunderstanding of how these records are used and how they're made available. I mean, it's number one by such a margin. There's not even a number two or number three to concern yourself with, because those things are so rare when they happen. These things happen almost every week. There's somebody filing a complaint because they're not being given access to records. So we're going to go into this stuff a little bit more. The citations are probably not near as important for you to write down, because I'm going to run through the actual numbers. They all start with 611, and there's a point or a decimal point, and there's a bunch of numbers after it. I would encourage you to just look it up. I mean, you can Google search, the mental health records, chapter 611, Texas. It'll bring the whole thing up and you can read it. I would encourage you to read it seriously and maybe print it out and hit it with a highlighter. I do it. It's been amended several times. I don't know when the last time this thing was actually amended. My hunch, it was probably about 4 or 5 years ago. I don't have the actual date of the amendment. I don't know if it's all that relative, because again, it doesn't include the teletherapy part, which should be part of what's going in here. Because a lot of folks that do teletherapy do not keep the same kind of records as when you're doing face-to-face work. And I'm not quite sure why that is, but I do know that apart from that initial evaluation, I've seen teletherapy notes, session notes, and my goodness, they're 1 or 2 sentences long, as opposed to actually doing, record when a client actually comes into your office. The time with them, same time you're spending on the telephone, or on a Facebook, well, not Facebook, but through Zoom or some other HIPAA-approved kind of access. And those notes are like scant, barely noticeable little things where you're making a little note about what you talked about, but it doesn't follow the same kind of protocols that typically we go through. And I don't know if that's because the venue is different, and we get, I don't know if lazy is the right word, but we tend to get into a mode of, okay, we got this client done, then we're moving on to the next client, then we're moving on to the next client. And it's a different perceptual awareness of what we are doing, which hopefully is going to become the basis for another workshop that we will put together, so that people can become aware of that. Because I think it's real important to understand what teletherapy is actually doing to the profession itself for those of us that are using it. So we will go a little bit further into that stuff. I've been asked real briefly, actually, my office manager came by and said, why don't you tell these people who you are and what you do? Okay, I'm going to give you a little bio stuff real quick. I've been in practice since 1979. I graduated with my master's degree in 75 from the University of Wisconsin. It was a master's degree program in counseling. And then I got my doctorate in 81 and ran the University Counseling Center for 4 years. I coached the hockey team over there, which had nothing to do with mental health, but I did more counseling with the hockey players and some of the students that would come to see me for supposedly counseling stuff. And from there, I came down to Wisconsin. I left Wisconsin to come down to Texas, which happened in 83. And initially, I came down here to teach at the University of Houston Clear Lake. Hurricane Alicia wiped out my assignment, my appointment, because the university shut down because most of the university was underwater. So I had a small little practice dealing with marriage counseling. I was working out of a church, and the church was eliminated by a tornado that was a result of the hurricane. And for 6 months, the sheriff's folks were constantly bringing me records that had been blown away by the tornado and relocated all over the Galveston County area. And you can imagine what the nightmare of confidentiality would be when you have file cabinets that are locked and sealed and protected in nice ways, and tornadoes rip them apart, and somebody brings you a copy of a test report. Yeah, it's kind of embarrassing, but that was part of what we were dealing with back then. From there, I went into private practice and started working at psych hospitals, and moved off into other areas. I went through certification to become a hypnotherapist. I've been doing that since '91, and became a sex therapist and got that certified in '95, and have been doing a lot of teaching, supervising. I do a lot of work with other people, training, formal training stuff. I am a certified instructor for hypnotherapy. I run classes. Generally, I run one class a year, and people become certified through the International Board of Psychotherapists. And recently, I've started doing a radio show, which I'm going to give you the call letters on that later. If you're interested in tuning it in, we do it every Monday morning, and it gets simulcasted out throughout the week. So it's just part of what the stuff I've been doing. In addition to that stuff, I have also been really focused on some work from a social standpoint of bringing mental health to people that typically don't have access to it. And in Texas, there are huge areas of the state where they don't have the ability to sit and talk to a counselor. They, up until the telemarketing, or not telemarketing, but the teletherapy, because of COVID, a lot of these rural areas were lucky to see a visiting guidance counselor in a school, because the consolidated school districts or the unconsolidated school districts that can cover hundreds of square miles would have one counselor that would bounce from school to school to school and do whatever kind of work that you can imagine a school counselor being able to do with very little coordination, other than the fact that he or she was there seeing students for a myriad of reasons, and then go from one place to another, sometimes only in the afternoon or morning, and taking in just hundreds and hundreds of students in very rural kind of locations. And that's their only access to mental health. A lot of the counties have what they refer to as tri-county mental health services, which would be like 3 counties getting together and having one facility available to have LPCs or MSWs and a psychiatrist that would come in once every 2 or 3 weeks. And that was their mental health access. In the urban areas, we're far more fortunate in that we can have a vast array of different kinds of mental health people. But my focus originally, well, not originally, but after I came to Texas, was just being aware of just how underserved Texas in general is with mental health. So from that stuff, I started bringing in lots of other areas. And I go up to Cold Spring, Texas. I don't know if you're familiar with where Cold Spring, Texas is. It's outside of Houston, good miles away. And we do different kinds of things. We do a meditation program there because one of the things we're discovering is that when you balance off stress by doing things to calm yourself and relax yourself, whether it's doing meditation work, whether it's doing prayer groups, whether it's doing self-hypnosis, all that stuff lowers down the anxiety. And when you can drop down the anxiety, the stress level goes down, the cortisol release comes through and drops that down. So people become less anxious. And one of the things we know is that when you are in a highly elevated state of stress, your body's immune system is weakened. And when you weaken the body's stress system, the ability to fight off infection, you're opening yourself up for viral infections, including COVID. So part of what we are going to do, hopefully, is to be able to educate people about how to relax, how to meditate, how to use self-hypnosis, because it's such an incredibly important part, and yet it's such an easy thing to do. It doesn't require hours and hours of therapy, in order to teach people how to relax, how to breathe, how to feel more comfortable experiencing what they're experiencing. So that's a little bit about what I've been doing and what my focus has been in right now as far as mental health goes. Back to 611. I will deviate, as you probably already discovered, away from talking just about ethics simply because it, can drive me a little batty sometimes. In section 11, there's a part that I want to talk about just a little bit that deals with the confidentiality of information and the prohibition against disclosure, meaning that what we talk about with our clients is considered to be confidential. As I've already explained, the confidentiality belongs to the client, not to us, and we must honor it. Now, they can sign a waiver, and there's specific things that goes into that written waiver, because it has to be in writing, that says that it's okay for me as the client or me as the parents of the client, if it's a minor, or if it's an adult that's been judged to be mentally incompetent, you're the guardian of them, that you discuss the treatment, care, the diagnosis, or whatever's involved in your mental health work with somebody else. That somebody else can be another agency, it can be some kind of a health center program, or it can be something involving legal stuff. And that release gives us the message that we are to release that information to the people that are being designated. Now, the release itself, and I'm going to just touch on the written release itself, because it's important to understand that a written release has to specify to whom it's going to, not just the state of Texas, not just a church or some other organization or the Veterans Affairs. It needs to specify a person. Who is it specifically going to, and why it's going there? What's the purpose of it going there? It's not just an open release that says I can talk about anything, I can send records concerning anything about the client. It needs to be specific. It needs to have a date on it as to when this thing is going to go into effect, and it has to have a closing date, meaning that at the end of this period of time, and typically it's 12 months, but it doesn't have to be, it can be for shorter time, that this release is no longer valid. And I have situations in the past where somebody who was a minor had a release that was signed by a parent in effect for 12 months. And 3 years later, I get notified by the client, who's no longer a minor, who's wanting access to the records because there was a release that allowed those records to go to somebody else. And what we have to be able to do is to get that person back into us, sign a new release, because the old one's no longer valid, because that person's obviously no longer a minor, so the fact that the parents signed for it is irrelevant, so that they can authorize us to send the records wherever they want them to go. We don't have, it's not just a blanket thing that forever and ever we're, given permission to send off records. So there's a time specification. These things have to be followed. There's a specific thing, and it's not considered valid. And when it's not considered valid, that leaves you open for a complaint, which is the last thing that most of us have the time, the energy, or the desire to have to experience, is getting a complaint filed against us from Austin saying, you're in violation of blah, 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 and they will specify what you're in violation of. And here's your hearing date, and you must appear. It's not a question of whether you want to or whether you can, and bring all the records with you, by the way, because the state does have the right to examine your records. It's a pain in part of your anatomy that most of us don't like, particularly to have to deal with. And yet the state can do that. And they really don't have a whole lot of regard for whether you're in Houston or in Austin or in El Paso or down in the valley. They don't care where you are, because if the complaint's filed, their job again is to protect the client. So if it's inconvenient to you, that's really too bad. Okay, so we want to be clear about what those releases are for, and if they have to be used. You don't just have the right. If somebody says to you, can you send these records over to the school so they understand it? Whatever they're trying to understand. There's an ARD meeting that's coming up, and you've done an evaluation. Or you put together some modifications that you're highly encouraging the school to adapt. You need a signed release to do that. And I would also encourage you to get a release for you to participate in that ARD meeting, just to cover yourself so that you know that confidentiality message is real clear, that you are there representing your client because your client wants you to be there. And here it is in writing saying, yes, you may come, you may disclose these records, this information. However, be real clear that if you're doing something for a specific purpose, you're being asked to come in to help an ARD process. So the release that you are being asked for from the client or the parent is to share the educational accommodations that are wanted. Okay, that's different than an evaluation that you've done on the client. So if you're being brought in to work on the modifications, that does not mean you disclose anything like a diagnosis just off the top of your head. Well, yeah, they're ADHD. We've gone through the screening process. They fit all the criteria for it. If that's not being requested in the release, you're not supposed to provide that. If they're showing up besides or in addition to the ADHD that you've been asked to do the evaluation on, and there's also some signs of depression, you're not allowed to disclose the depression part because it doesn't fit the release. And that's not why you're sharing the information. Even though you have access to it, even though it might be useful, for that group of educators to be able to put together, a plan of how they're going to proceed to educate the child, unless specifically asked for it, you're not allowed to disclose it any more than any of the anecdotal information that's also been shared. The school does not have access, or should they be asking for access, if this child has a history of self-mutilation, or they've attempted suicide, or that there's a sexual abuse history, if it doesn't pertain to why you're being brought in to help put together the accommodations for a specific educational need. We don't have that broad brush spectrum of openness to share. That's not our right to disclose. Similarly, if you are brought in to do an evaluation for a custody issue concerning visitation or any modifications that may be going on, the attorneys will issue a summons to you with a release that's signed by their client. That subpoena that you get must specify exactly what it is they are wanting your expert opinion or your expert knowledge of to disclose. It is not a broad brush thing that you come in and you talk about every clinical thing that may have come through your door concerning that client. Because the client's right to confidentiality means that it's their choice, regardless of what an attorney may want to see. Or in cases of disability, what the disability insurance company may want to see, because their goal is to invalidate a claim for disability. It's not to act on behalf of the client that's filing for the disability. So you want to be real clear of what is that release asking for and what are you being asked to provide? Because your job is to protect your client. It's not to be a nice person and provide information just because you like the people that are asking you. And we've had situations come up, especially dealing with kids, whether it's protective services that wants information about something that's going on in the family environment. If the release doesn't specify it, you're not allowed to provide it. Whether it would be beneficial or not is irrelevant, because you need the consent of the parent, or protective services taken over. If the state has actually taken over temporary custody of a child because of the abusive family or an abandonment issue, they take on that responsibility of acting on behalf of the child, and they can ask for the release of confidentiality information directly to them, which you have to provide, because they are now acting on behalf of the child. So their role becomes shared with your role. They're just providing different kinds of services. But that's different than somebody who's wanting to find out information or investigate. The other thing that's also involved in this thing, which is an interesting little quirky thing that I've run into twice in my entire career, but I'm going to put it out there because it does happen. What happens if your client dies? Who has the right of confidentiality at that point? Now, if it's a child or a minor or someone who's under the guardianship as an adult of somebody else, that right of confidentiality is still clear. It doesn't go away because the client died. But if your client is an adult who's not under guardianship, who has the right of confidentiality at that point? Because technically, it's that dead person. It hasn't shifted. It hasn't changed. You become the person who takes on responsibility for that dead person. It's not a spouse. It's not children, adult children, unless they have a power of attorney that specifically gives them that right. You are the person now responsible for their records, not just because you provided the service, but because you have to act on their best interest now that they're dead. And there have been investigations that have gone on because there may have been some criminal issues that were happening, And because the prosecutor wanted to find out more information about the person who died in connection to a case that they're working on, that they've notified me asking for those records. And I've had to say no. Because I'm not authorized to release those records for an attorney, whether they're representing the state or a county or private, to go on a fishing expedition to see what might or might not be there that would have helped them in their case. That's not my role. And you need to be careful in terms of how you expose that, because you're still representing the best interests of your client, even though they're deceased. Okay. Let me throw this out before I forget. One of the things that I want to be able to do is to let you all know that after doing this for about 60 minutes, my body needs to move. I don't know about the rest of you, but I get tight. My body has to get up and stretch a little bit. So we will be taking about a 5-minute break when we get up to the top of the hour. So just to let you know. See, the interesting thing is while you're listening to me or watching me do this, I have no way of knowing how many of you have gotten up and gone to the bathroom in between or gone up and got another cup of coffee. What I know is that I can't do that because I'm talking to you guys. So I'll wave my mug and hopefully if somebody sees it, they'll bring me some more coffee. But I do need to get up and move around a little bit. Otherwise, my body tends to tighten up on me. So it's just one of the things I would do. So when we get close to hitting the hour, I will just let you know that, in a minute or two, we're going to take a break. So you're free to get up and move around the cabin or whatever it is you're doing. And then we'll get back and we'll resume at the end of that part. Okay. Just wanted to put that out for y'all. All right. Let's move on a little bit. The section, the 611-003, deals with people that can claim the privilege of confidentiality. And it goes beyond the patient, again, they identified the statute as being the patient, into the other people that are affected by this thing. So the professional, us, the mental health provider, is acting on behalf of the patient. So we will honor whoever else is looking for it. Now, there are people who are authorized to receive these records. And what we have to be very careful of is that who is actually allowed to get these records without having to get a release from the client, and who's not allowed to have access to the records. And it's all spelled out in 611. It's very clear. It's not ambiguous at all. It clearly states, I'm not going to read it to you, I don't want to bore you to death with this stuff, but I would encourage you to, take a look at 611, especially 004, where it actually goes into, these are the people who can have access to these records. These are people who need to have a release, and these are people you probably shouldn't send out at all because they don't have a vested interest in what's going on with this client. So it's very clear what's there. And the last thing you want to do is to violate that stuff. You don't want to get a knock on the door or an email from a police officer saying, we're investigating a crime that involves your client, and we need to have access to their records to find out whether or not this person was acting of sound mind at the time they did whatever the heck they did. Well, you are under no obligation to release those records. And in fact, you may not release those records. I don't care what your relationship is with that police officer or detective. It doesn't really matter because it's the client's records that you're protecting, not yours. And regardless of how nice those people are, they need a signed authorization or they may not access them. Several years ago, I don't know why I'm not getting it recently, but several years ago, I used to get lots of requests from recruiters, Army recruiters, Navy recruiters, wanting access to records because a person, 18, 19-year-old kid would go in, volunteer, to go into service. And one of those application questions deals with the fact that they've been receiving services for any kind of a mental or nervous disorder. And if they check off yes, then they indicate who it's to. Now, that does not by itself give that recruiter authorization to get records. The client still has to a release for why those records are being obtained, what the purposes of it is, an opening date that has to be signed, and a closing date when it's no longer valid. And there's one specific case that I got, many years ago, is that a young man had volunteered to go into the Marines, and there was a signed release, and I shared the information, not with the recruiter, because it's not a recruiter's job to get those kind of records. It was from a medical person who was evaluating this recruit to determine whether there was a fitness for duty, issue there. And the actual request for the records came from a physician. Now, physicians by themselves may not know a darn thing about mental health, as I'm sure we've all experienced. Those of us who've been in the field for more than 13 days, we know that just because there's an MD after a person's name does not qualify them. to actually understand what it is we do. And oftentimes they don't understand what we do. So part of our job is to educate these people, which is not part of the confidentiality information. But as a professional, it's kind of helpful to let these folks know that we do this kind of stuff. And medicating people for every single thing that we help them with is not necessarily a number one go-to kind of remedy. But beyond that, the request that came in from this Marine physician was that, you know, he wanted the records of this person. And we did that. I called that individual up. He sent me verification that he was in fact a physician and not just somebody in the recruiting office that has really no right to those records. So we did, and I sent the records over. The individual was brought into the Marines, became a Lance Corporal, did, I think, 6 years, and then volunteered for some special services. I get a phone call from somebody in special services wanting copies of records because that individual indicated he'd previously received counseling help from me before he went into service. And I had to tell him no. And they said, we have a signed release. And I said, send it to me. So they did. It was the original signed release from 6 years before that this 19-year-old kid had signed. And I had to send back a response saying, I'm sorry, but these are no longer valid. I will need a new signed release. And what I got back was a very nasty reply saying, time is of the essence. We have to get him into the special training. He's being shipped overseas or scheduled to be shipped overseas in less than 6 weeks. The training runs 5.5 weeks. This has got to start today. And we can't let him start unless we know he's not going to go wacko on us. And I said, thank you very much for that insight. Get me a signed release. And then he proceeds to tell me that he's in Bethesda, Maryland, and this training program is going on in Camp Lejeune in the Carolinas. And he has no way possible of getting to this guy to have him sign a release and to have that forwarded to me in enough time. And I had to tell this guy, I'm sorry, I need a signed release. And he proceeded to scream at me, curse me out, call me every profane thing he probably has ever heard in his life, and then slam the phone down on me. I then got a phone call later that day from the guy, the client, who's now a young man, wanting to know why I ticked off this guy trying to get records. And I had to explain to him, I need a current release. And he said, well, how do I sign one of those? And I said, well, I tell you what, given what we're dealing with, I'm going to dictate to you. You write it out by hand because that is legal. I will give you the information and you send this thing to me. Fax it to me, because at the time we were dealing with faxes. Fax it to me. I will get the records. You designate where the records are supposed to go, and I will make sure that they get out. I never got that from him. He never sent me the release. Consequently, nothing ever left my office. I don't know what happened to the guy. I don't know if the guy did a special program regardless of that. But the point that I had to establish is that the records belong to the client. The signed release had a validating date on it. Beyond that date, I can't release those records, regardless of who wants them, even the Marine Corps, because those records are privileged. Okay, it's an excuse, but there's plenty of these cases. And I'm sure most of you who've been in the field for more than 5 or 6 years have probably run into situations. If you've been in the field for more than 10 years, I'm sure you've run into these situations. And if you've been in the field for more than 20 years, you've probably discussed it with some of the cases you run into, where people try to side skirt it, or they try to be nice and they try to send you things, and they're looking for favors and wanting. And I'm sorry, but if you're going to follow these codes to keep yourself out of trouble and to respect, the confidentiality right of your client, these things almost have to be enforced by you, or your client's right is being waived, and you don't have the right to waive it. Okay, so that's the kind of messaging that this kind of material, 611 specifically, addresses. And you need to be careful with it, because some of it's exact, some of it pertains to legal matters, some of it pertains to non-legal matters. I think the exact wording, I'll give you the actual wording of this thing, is authorized disclosure of confidential information other than in judicial or administrative proceedings. And there's another section that deals with information that directly relates to judicial and administrative proceedings. Okay, so there's both things are covered under this code, and I would encourage you to take a look at it just to keep yourself out of trouble and to be real clear that when you're talking with your clients, you're giving them the information they need. So we are up against a break. My body is now telling me that it's time to do that. So we're going to take a break for about 5 minutes. So I encourage you to go do things, stretch your body out. And when we come back, we'll pick it up with some more stuff.
Awesome. Thank you, Dr. Lerman. Good information, and looking forward to hearing what you have for the next hour. I'm going to share a little bit of information about our sponsors today, Starlight Recovery Center and IntraCare North Hospital. First of all, let's, if you're still around, and you can take a break if you want to, let me share a little video about Starlight Recovery Center and what we have to offer. Just one second here.
Starlight changed my life.
I felt like they actually cared about me living.
This is where I decided to finally, at 42 years old, get serious about my recovery.
Not only did I get sober at this facility, but now I have a chance to advocate for a client who's sitting in the same position that I was 3 years ago.
You can be sober and live a fun life. You can go out and do fun things and actually remember them. Also, that your fun can have purpose.
I got to learn about the disease and what it meant to me and what I needed to do.
I feel like Starlight has such a well-rounded program for all this kind of stuff that whatever you're going through, whatever you've been through, they have something for you.
There was never a time where I felt like I was being talked down to. I felt like I was being related to. I would not be where I am today if it was not for Starlight. I have hope. I live every day very grateful, thankful.
I can feel again. Like I feel happy again. These people kept me alive.
You know, and I get to do normal things like enjoy dinner, enjoy lunch. You know, I remember the movies I watch now. I remember the TV shows I watch now. Just having a little bit of willingness and open-mindedness to take some suggestions from these guys. Within 45 days, my life was changed.
Thank you for listening to the brief introduction of Starlight Recovery Center. We are one of the oldest addiction treatment centers in the U.S. And Texas. Some of our special programs include the Freedom Program, which is a program designed for our clients that are LGBT plus, and we have special programming for that. The Journey program is a program for people that like the Christian curriculum, and we have a beautiful chapel on campus and have worship on the weekends. We also have a Valor program for military and first responders, heavy modalities with trauma and PTSD. We offer EMDR, and also our CEO and our director of nursing are both veterans with a lot of our therapists. So for more information, go to our website at starlightrecovery.com. Suzy, are you still with us? I want to also introduce our co-host today, IntraCare Behavioral Hospital North, and this is their information on their website, intracare.org. Thank you to Suzy for co-sponsoring today and letting us be part of this this ethics webinar. So let me turn it back to you, Dr. Lerman.
Okay. That's quick. We all back?
Do you want to take some questions?
Sure.
Well, let's look at some Q&A here. Okay. We have Shelley Rana who says, in the age of internet and teletherapy, reciprocity seems silly. Well, I guess that's not really a question, it's a statement. Okay.
Yeah.
Debbie Guidry says, what is the amount of malpractice coverage we should carry?
Okay. Well, I personally, yeah, I don't know how to answer this personally. What I generally recommend people carrying is a 1 million per incident, 3 million aggregate. It's broken down. The aggregate, what that means basically is that in any one event, if you get sued, you want to have $1 million worth of coverage, and you want the term of your policy, which is renewed every year, to cover up to $3 million total. So if there's 3 infractions or whatever, you're covered up to $3 million. That's kind of a standard thing. Some people have gone to 5 million. I personally, I don't see a need to cover that much, for your own coverage, simply because so very few people, mental health people, are actually sued. Psychiatrists are the biggest group of people who are sued. If you look at all mental health folks that actually have lawsuits thrown at them for malpractice, psychiatrists are about 85% of them. Okay, out of the remaining total, psychologists get about 12%. And believe it or not, pastoral counselors get sued more than LPCs and mental health counselors get sued, because people are really upset. And pastoral counselors typically are dealing with grief, dying, those kind of episodes and those things. And families can be very split about how they're experiencing the death of a loved one. And a lot of times the person that tries to intervene on the behalf of the person who's dying gets thrown in the middle of that conflict. And we start talking about splitting, assets and going through wills and all that kind of stuff, which a pastoral counselor has no business getting involved in. What ends up happening, they get thrown in this process. So a lot of times they get named in suits because family members can't come to an understanding as to how to deal with whatever they're dealing with their grief, and they get dumped in there. The actual mental health counselors themselves, we get sued about 1% of all the mental health suits that are out there. So having coverage is important, and most facilities won't let you operate in their facility without coverage, which I think is a good thing. When I'm supervising interns or associates now, I have them covered themselves. You've got my own general umbrella policy, but they need to be covered too, just in the case it might happen. Insurance is really intended to be the buffer in case something awful happens. And then you said about everything you possibly can do as a professional, make sure it doesn't happen that way, if you can possibly avoid that stuff. So it's generally a 1 million, 3 million thing that I look at for coverage. I don't recommend going less than that, nor do I really see a need to go beyond. The question about the telemarketing thing that came in wasn't a question, a comment. I agree, it's totally insane that we should have restrictions about reciprocity that don't allow us to practice outside of our states. To me, it doesn't make any sense, but we're not in charge of who makes those rules, unfortunately. So if you do it, just keep in mind that you're running a risk. And I know there's organizations, there's companies you can join. BetterHelp is one of them. There's several of these things where we can go on as private practice, and we can take on, teletherapy sessions with people. We get paid a minimal amount of money. It's not a big chunk of money we get paid for it compared to what we normally would get in private practice. But they will pair us up with clients that are looking for help. Now, they have become more conscious of the fact that just because psychologists may have reciprocity, the rest of us mental health folks do not. So they will try to pair us up with clients within the states where we're practicing, but not always. I can think of, I had a couple of referrals that my intern actually got. They were from Florida. And here we are in Texas. And I had to tell her that, if you decide you want to work with this client, keep in mind that we're not in compliance with Texas code. And I had to advise her that would not be a choice I would make for her. So yeah, it is kind of an absurdity that we have to deal with, but we do. So what other questions we got?
How long are we required to keep client records? 5 years?
Well, 5 years, unless they're minors, and it's 5 years until it's 5 years after they become no longer minors. So if you see somebody who's 11 years old, you keep their records until they turn 18, then add 5 years to that, and then you can get rid of the records.
Okay. Would you have a sample of a release of information and consent form?
Yes. Send me an email. I'll be glad to send it out to you.
I'm an LCDC at Probation. I'm always instructed that the client's files are not theirs. They actually belong to the court. First, is that correct? Second, how can I stand up for the client and myself if it's not correct?
If you are an LCDC, my understanding is that you're not licensed as a mental health provider. You're licensed as an alcoholic drug abuse counselor, which used to be a certification thing as opposed to a license. The records that you maintain for that agency, if it is a court-mandated agency, belongs to the court. The client still has a record, still has a confidentiality issue, but it's joint, it's shared, because they're participating in a program that's being mandated to them. So part of that mandated process entitles the court or the agency to have a right, also a shared right of confidentiality. So the records technically do not belong to the client, although they have to be shared with the client. So if a client wants a copy of the records, I do believe you would be responsible for giving them a copy of it.
Okay. The military has me follow my clients all over the world as they deploy. You say Texas has a problem with this. Oops, federal versus state.
Okay, the issue of confidentiality is not a federal issue, it is a state issue. Following your client out of the country is fine. Following your client in other states is not okay. So technically, what you would have to do is, if your client is going through basic training in Camp Lejeune or Fort Campbell or someplace out on the West Coast, that becomes the jurisdiction of those states. You would be transferring your care to somebody in those states while they're there. Now, at the point at which they go overseas, if they get shipped out, you can resume it, but it's not an automatic thing. It would be up to the client if they wanted to continue working with you on a teletherapy basis or some other capacity when they come home for leave or whatever. Internationally, there is no governance when it comes to who provides service, except some countries. England is one, where if you're from another country, mental health services, you have the option of whether you want to continue to work with your person or whether you want to switch it over locally. Other countries have no consideration for it whatsoever. But within the United States, the federal government does not have jurisdiction over this thing because they cannot mandate confidentiality.
Okay, someone has made a comment. LCDC is a license. Okay.
Yeah, it's a license. It used to be a certification.
Jeffrey Tepper says, a lawyer asking you a question outside the bounds of a release. In another state I'm from, the judge can order you to answer the question, and that supersedes client confidentiality. Is this the case in Texas also?
Criminal cases, yes. Civil cases, no. No, the judge orders you to relinquish information because your client is involved in something. You cannot deny a judge access to getting that information. What you can do is to inform the judge that the information you have is particularly sensitive, that you would much prefer sharing that information with the judge in chambers as opposed to an open courtroom where those records suddenly become available to the public. And I've had situations where the judge has been very agreeable to it. They just wanted to know what the heck's going on with the client. So I was able to share that with them in chambers, and we come out of chambers, I go back on the stand, and the attorneys are wanting to know what the heck happened, and the judge says, it's confidential. And we just proceed. So it depends. A bench subpoena is different than an attorney subpoena. They don't have the same power in law. Okay, attorneys technically in Texas are officers of the court, but it doesn't give them the ability to obtain confidential information relating to mental health records without a signed release from your client, just because they're an attorney.
Okay. Your next question is from Ruben Vasquez. Which is the best way to send consent form, release of information, etc., when we can meet with client, I think it's supposed to say, when we can't meet with clients physically? Which is the best way to send it?
Facsimile is considered legal as long as it's signed. You don't have to witness the signature, as long as the person sending it to you is authorizing it to come. If I get a fax from somebody, my immediate response is to call them. I want to make sure that they're the ones who sent the fax. I don't want somebody just loosely having a fax or a release signed without the client really understanding why they're signing that information. And it's still my job as their provider of service to make sure that they're understanding what that information is being used for and why. So yeah, faxes work. You can scan stuff and send it by email. You can send it by snail mail. You can have it brought in personally. Generally, any way that you get that release is fine. My personal preference is that anytime I get it electronically, to call the client and verify. And then I put it in the note, I put it in my chart note that, the client has authorized, the release of this information as well.
Christopher Anderson asks, does the protocols in client confidentiality the same with DFPS as with court-ordered proceedings?
Yes and no. It's one of those ambiguous kind of situations. The system is designed to provide a specific service to a specific client. If the client is yours and it's also involved with another state agency, then yes, you can share information as long as you have a signed release. If it's not, if you're working with an agency that is looking at the children of your client and they're wanting records, your records of therapy sessions that you've had with a parent of a child, you need the release from that parent before you sign the information off. Okay, the confidentiality issue still remains with the client. Now, the only thing that gets in the way of that, which is why I said sometimes, is if the state is investigating an abuse situation involving your client, they do have the right to access those records.
Okay. Ashley Thompson asked, how should I instruct my client if they are wanting copies from their probation file, but I'm being told they can't have them?
Probation records belong to the state. They do not belong to the client. Your counseling notes as a probation officer do not become part of that probation record. They should be kept separate for this very reason, that if you're providing any kind of therapy to your client, as opposed to just probation officer relationship stuff to an offender, that information belongs to the state. But if you're doing some personal counseling with them, in addition to making sure that they're getting their hours of service in and the other things that standard happen, their standard procedure that PO provides, you keep those records separate and they become your counseling records. And those counseling records then are shared with the client if the client wants to access them and see them. But those don't belong to the state.
Corey Morlock asks, with clients under federal probation, a state subpoena is not valid and can be refused. It would need to be requested from the feds. Okay.
That's true.
I guess,
Yeah, that's definitely true. Yeah.
That was not a question. Sorry about that. It was a statement.
That's my understanding. So I would be in total agreement with that. Yeah.
Are any of the emails HIPAA compliant?
No. Yeah, I tell people when they first come in for their very initial meeting that emails are not a HIPAA-approved means of communication. If you want to send me information relating to your care, do not do it by email. We have other ways of communicating. We can do it by phone. We can do it in our next session. You can write me a letter, but email is not a secured method of communicating confidential information. Nor do I recommend people sending me stuff that they scan and send by email. I've gotten psychological test reports from folks that should never have been, attached by email, because email is not a secure HIPAA-approved way of communicating. So no, I do not rely on emails for anything besides if somebody wants to confirm an appointment and they're telling me that, that's fine. They're giving up that right of confidentiality, and if somebody finds out they're coming to see me because of an email they send me, it's on them. But they are told up front that emails are not a protected way of communicating.
Yeah, that's the way we do things at IntraCare. It's fax. Yes.
Yeah. Dr.
Ashley
Lerman,
Thompson.
let me ask real quick.
Yeah.
The consent forms that you were talking about, are those located on your website?
I do believe they are now. Yeah. Yeah. We did some of the stuff on our website. Yeah.
I'll post a link for everybody that requested those. We've had quite a few people asking about the consent form, so I'll put that on the chat box.
Okay.
Okay, Ashley Thompson has another follow-up question. Also, what if there's incriminating information on a probationer's file that could possibly lead to a new charge, and my file/notes are subpoenaed?
Again, you want your counseling notes kept separate from your probation notes. And that's a good reason why. Okay. What is shared with you in privacy of a counseling context, which is different than a probationary officer's meeting with a probationer. Okay, those are different functions, even though they may happen at the same time. Okay, part of that's confidential between you and your client. The other part is not, which is the information that is exchanged because you're dealing with, as a probation officer, with your probationer. Okay, that's the reason why I recommend keep them separate, just to prevent that kind of a situation happening.
These are great questions. I'm really enjoying these.
Yeah.
Lynn Stevens asked, during this time of COVID, we are seeing clients virtually by telephone or video. They are giving us verbal ROI authorizations. Is this okay?
Nope. It's not. Yeah, we want to comply with it. We want to be helpful to these folks. I get that. But what we don't want to do is violate the state code in the process. And it was one of the comments that I made earlier. It's so convenient to be able to talk to people this way, different than in your office, which seems to take on more of a formal context. But we still have the same rules to follow, whether we're doing it by, by this kind of an interaction or over the telephone. And I've had counseling sessions over the telephone too, and they can work depending on what the kind of counseling work you're actually doing. However, it doesn't take away the confidentiality issue. It doesn't negate it. It doesn't really alter it at all either. Because part of what you want is the authorization from your client to share information over the phone and to do it safely. So that, again, what we're looking at is protecting the right of the client. Whether it's convenient to us to have a different kind of modality for interacting with them or not is irrelevant.
Okay, Janie Lopez asks, what if we do contract work and the company I contract with has their method of maintaining records on software? COUS counsel, do I need to keep copies too?
No, because again, the records belong to the client, not to you. The agency that you are contracted with is responsible for housing those records securely. So as a contract laborer, you're providing a contract service for that agency. The client that you're working with technically doesn't belong to you. It belongs to the agency, and the records belong to the client. So you're kind of the middle person out of that situation. So under no circumstances should you be taking counseling records away from that agency and putting them in your house or in the back of your car. I had one gal that came in. She actually would bring this file, this plastic thing with files in them, 35, 40 files in them of her clients. And I looked at her and thought, what are you doing? She was coming in because she wanted to do a consultation with me because she had been hit with a show cause thing that came out of nowhere because of the ex-spouse of her client wanted access to records. And she literally took them out of the agency where she was contracted as a contract labor person, and she was carrying them with her.
Oh.
And they would stay in her car when she was doing other things. And at night, she'd bring them into her house and she kept the records. Legally, the records don't belong to her. They belong to the agency. And even if you're contracted, the agency is still responsible for their safe upkeep. And they belong to the client. So yeah, being contract, is really wonderful stuff because you don't have to worry about those records. If it's stored in the cloud, great, as long as the mechanism of getting into the cloud is HIPAA approved. If it's not, that would be an issue you want to raise with the agency that you're contracted with. And you want to make sure they're not being stored in some janitor's closet overnight, which has happened before.
Joe Espinoza asks, what are the complications of verbal consent with patients with records?
Verbal consent is not authorized. It's not recognized as basically worth anything. If you were a priest and you were getting a deathbed confession out of somebody, that verbal consent that you might get, that would be legal. But it would take that kind of an extreme case for it to actually become a legal binding agreement. Everything that comes about with release of information is signed. It's always been that way. and I can't imagine it ever changing.
Hmm.
And we've gotten battlefield confessions out of people, which are fascinating things, but they're not considered to be confidential because the information came and the person's dying, and they'd say, "Get hold of my ex-wife, tell her I really did love her all this time. I didn't mean her any harm." Okay, fine. I feel badly because this guy's dying. It'd be nice if you'd been able to share that information years before they got divorced and all the bad stuff happened. But the point is that that's not a release of information. That's not an authorization to release information. It's an unfortunate situation. But releases have to be signed.
Okay, we have 2 more questions. We'll let Dr. Lerman keep going. And then if you have any more questions, please put them in the Q&A and not in the chat, because the Q&A is what I'm going to be reading from.
Yep.
Pamela Ogletree asked, how do you receive your client intake information for teletherapy if email is not protected?
I have them either fax it to me, or I have them bring it in during the first session, or at the beginning of the first session, or just drop it off if that's possible too. But I will tell them straight up, please do not email it to me. I will take faxes, that's fine, or snail mail.
Okay, and your last question from Reagan McGann. Is substance use by a minor confidential between the therapist and the teen? I've been told substance use is protected by the client-therapist relationship, but how do you manage that confidentiality when the substance use is documented in the progress note and the parent can access the records?
Good question. There are different levels of protection. The federal government has a standard of how to protect alcohol and drug abuse issues for minors, which is different than the state of Texas. When in doubt, I default to the federal government when it comes to what's confidential and what's not, because their stuff supersedes the states. So there are certain things that maintain their confidentiality for a minor related to drugs and alcohol. It doesn't pertain to other mental health stuff because the feds never got into the other stuff. So if you're dealing with something like that, the record becomes confidential. And even though the parent may have a right to those records, that's what redacting becomes. And you would actually take a black indelible ink marker and wipe that stuff out of the records that you would present to the parent related to that specific action.
Wow.
And you let the parent know that the redacted information is protected by federal statute regarding adolescent or minor confidentiality. So they're being informed as to why it is you're not sharing the information with them, because that also is part of the Texas statute. If you are going to deny access to records to a parent, you must provide them with an explanation as to why.
Okay. Well, we can take some more questions at the end if you'd like to go ahead and proceed with your presentation.
Yeah, we'll leave a few minutes before we get to up against the 11 o'clock, so we'll be able to take the questions. And yeah, the other thing is I'll make sure you all have my access to my email and stuff. So if you want to ask me questions after we're done, you can still do that, and I'll respond back to you that way too. Okay, so we have, let's get into divorces and custody things, because that's always a major issue. It's also, there's a lot of stuff that's covered under that in 611, even though they don't specify what happens with divorce and, mediation sessions and, the issue of visitation and modifications. It's a pain in the butt for those of you that have been involved with those kind of situations. There's, unfortunately, the kids get thrown in the middle of this thing, and the battle that goes on between parents is unbelievable sometimes. It becomes extraordinarily awful at times. We get parentification issues that are going on with the kids. We get alienation issues going on with the kids. We get disgruntled parents. We get narcissistic parents. We get borderline parents. We get all kinds of weirdness when it comes to dealing with divorce and custody and modifications and visitations and who's doing what. And you get thrown in the middle of that sometimes, not even realizing you're there. So there are some certain things that are covered by 611, and there's some things I'm going to suggest to you to keep you out of potential trouble because of 611. The person who receives information from a confidential communication or records may not disclose the information except to the extent that disclosure is consistent with the authorized purpose for which the person obtained the information. Okay, I just read that directly out of 611. It's from section D, number 11, that deals with who can have access to the information. So when you get a request from a parent that's involving a divorce or a modification to the divorce, there's certain things that you have to put in place in order to respond to that. First of all, if the divorce happens before you start working with that client, you should have a copy of the divorce papers. It's mandated by the state regulations. It's not an option. So any child being raised in a family in which a divorce has happened and there's custody, you must obtain a copy of the divorce decree, and not just the 2 pages that talk about who can get counseling or psychological services. You must have access to the entire divorce thing and keep it on record. And I know some of these divorce things, when you get them in the mail, can be like a briefcase full of material, it can be, 200-300 pages long. And yeah, I know it's got to be scanned in. So you may want to, just hire a professional, company to do the scanning for you, put it in the cloud, but it's something you have to be able to access. And print out those specific pages that deal with what happens here. Who's entitled to receive services, who's entitled to receive records. It is not uniform. And there are standard ways of doing it. Standardization is not always in effect. Sometimes the non-custodial parent still has the right to take the child in for counseling services. Sometimes it's specifically stated they may not, unless it's an absolute emergency. If the child's in possession of the non-custodial parent and there's an emergency situation that comes up, that parent would then have the right to take them in for emergency treatment, but not ongoing therapy. Other stipulations say it's okay for either parent to do it. In joint custody situations, again, it's always stipulated in those divorce papers who has the right to do what with that child or children concerning mental health issues. You must follow it. You do not have discretion to ignore it. So if a parent brings a child into you during the summer or during the Christmas break, or during any of these little mini week off things that public schools are now working in Texas with, if that happens, and part of your intake should be, has this kid gone through a divorce? Have you as a parent gone through a divorce? Is this child, visiting with you because the primary care is through the other parent? And because you're concerned about something that's going on, you're bringing the kid in to get an evaluation. Show me your divorce papers. It is a mandated thing. You don't have the ability or the right to say, sure, let's take a look and see what's here. And oh, by the way, bring me in these records. One doesn't happen before the other. Okay, you get the records first, which should happen on the call that they make to schedule the appointment. It should be a question you're going to ask, or somebody in your office is going to ask before the appointment's scheduled. If you're getting a request to see a child, the question goes out, is this child part of a divorce? Is there a divorce proceeding going on? Or is it involving a custody issue? That triggers off the next statement that I need to have a copy of the divorce papers. Okay, it's not an option. And it is a major issue, major conflict issue, because if the custodial parent finds out that the other parent has taken their child or children in to get evaluated, you are under a lot of pressure at that point. Because number one, it is not something that you have the authorization to do, regardless of the situation. Unless you're providing an emergency care situation that means life and death. It doesn't mean, oh, I'm afraid the kid's going to slap me, or I'm afraid I'm going to slap the kid, or kids telling me they're being abused in mom's house, or whatever the situation may be. That's what protective services are for. It's not for an independent contractor. Nor is it something for a school counselor to start working on after hours. And I've seen that happen in a couple of cases. Because you're really wanting to help this kid out and you realize the kid's in trouble, and the parent calls you up who's not in custody of the child and says, would you be willing to work with this kid after school a little bit? He's really having a hard time, dealing with what's going on in mom's house or dad's house. And you say, sure, it's no big deal. I'm a counselor, I can help him out. Well, no, you can't. Not without access to those divorce papers that clearly say that this is not a school activity. This is something that's happening after hours. And as much as we would like to, because we're giving, caring people, we are compassionate, we want to be able to help these kids out, the state is not going to say, that's okay. The state's going to say, where are the divorce papers? Where does it say that this parent has the authorization to seek services for this child? So it's an issue that comes up frequently, and it's something we have to be careful of. And it's also an issue that is governed for teletherapy as well. Because we will get calls occasionally from folks that are from different areas of the state or from overseas. And the parent is saying, I want my child to be evaluated, or I want you to talk to my kid they're having some problems with some grief issues, you still have that same obligation to ask, is this child from a divorce situation? If they are, I must have a copy of your divorce decree. Even through teletherapy. Okay, it doesn't eliminate that need that we have to protect. Okay, so hopefully, yeah, it brings up questions all the time. We also run into situations where we have disability cases, injury cases that are involving similar kinds of issues as far as psychological services. If we are working with a client who then becomes injured on the job and now they go into disability, chances are if we're seeing them and getting paid from an insurance company, from their major medical plan, that stops when they become disabled. And the disability insurance people pick up the care at that point. And if we are not on that panel and we don't have an arrangement made with the disability people to continue working with the client, we have an obligation to work with the client until we can transfer their care. However, we cannot bill them beyond what the original agreement was with the insurance company. So we are not entitled to receive payment for working with clients who switch from a major medical plan that we are covered because we're providers over to a disability thing. And yet I will see this thing come up several times. I have seen it come up where the counselor continues to work with the client and then expects to get paid. But they'll get the thing back from Blue Cross or Aetna or whoever was the primary. We're no longer providing services for them because they've been disabled. And then you, in panic, will try to get hold of disability people, and they'll say, you've already provided the service. We didn't authorize it, so no, we're not going to pay you. And then you turn around and try to bill the client for it, and the client's going to go, I ain't got no money. I'm disabled. I'm not working. Okay, and basically at that point, you're out the money. You have provided pro bono service. Whether you like that or not, that is what happens. So we got to be careful about how we do this kind of stuff. Not to get ourselves in trouble, because if you then go ahead and bill the client can turn around and file a complaint. And the state is going to ask, why are you billing this client for services when you know that they're disabled? Are you looking out for their best interest or your own? And one of those guidelines that's in the state code is that you may not profit by maintaining a practice that is not taking your client need into consideration. And people can get in trouble for that stuff. So again, it's part of what we got to be aware of. It's not difficult to ask, show me the divorce papers. I have to see them. I realize it's a pain in the butt, but I've got to have a copy of that stuff. That can be sent by email, by the way, because it's already public information. So you can just say, scan it to me. And if it's 20 pages long, fine. If it's 185 pages long, that's fine too. Scan the stuff over because I have to have access to it. I have to be able to see it. And that keeps you out of trouble. And if it turns out that it clearly says that this parent does not have the right to seek counseling services independent of the custodial parent, then you don't see the client. Not until you get consent, and there's nothing that stops you from calling the custodial parent and saying, hey, your child is apparently has some issues that they're trying to work on. Your ex is wanting to bring them for service. Is that okay with you? And if they say yes, then say, please send me an authorization to allow that to happen. Mail it to me, fax it to me. Again, you don't want to use email for it unless you let them know that it's not protected. You certainly can email it to me if you want, but I can't be responsible for whether it's confidential or not. Okay, and again, this is to protect the client. So you don't want to make assumptions about how to serve your client unless you know that you have legal standing to do it. Okay, hopefully we covered that. Probably beating that one into the ground a little bit. Who has the right to the records? This is a question that keeps coming up. This is section 611.0045. Your job is to protect your client, and those records are part of that protection. If you are going to deny access to anybody who is asking for those records, including a parent or a guardian of an adult, you must provide whoever's asking with a written explanation as to why you have to act in the client's best interest and not release the record to them. If you really believe that if that individual were to get access to those records, it would put your client in harm's way, regardless of whether it's a parent or a guardian. Presumably that would be based on the decision you are making because you have direct access to that client telling you that, which would be documented in your notes. And it must be documented in your notes, by the way. Okay? That keeps you protected. And you do have the right to refuse, as long as you provide that written explanation as to why. Now, when I get those kind of requests that I cannot fulfill because in good conscience, I know that this kid has been telling me how terrified he is about being in mom's house or dad's house, or when they're not there, there's a girlfriend or a boyfriend that happens to be in the house and they scare the hell out of this kid, or they've threatened the kid, or in some ways made that kid's life awful. Yeah, I will give them that information. I will also tell them that if they would like, I will give them a summary, a treatment summary or a narrative of what has transpired during the time that I've been working with the student, with this person, with the child. However, it's not going to be specific details. It will not include a diagnosis. It's simply going to identify the work that we've done together. How many times I've seen the person, whether the service has been paid for or not, the general issues that have been talked about, not specifics. And that's the information that I will share with them. If they want more information than that, they are going to have to do something to get that information, to take it out of my hands to protect the client, meaning it would have to basically go in court. And again, it would be for the judge to decide, not the attorneys, in terms of who has access to that information, and which then usually puts me into a place where I'm meeting with the judge independently in chambers. I will share the information with the judge then will make a decision. If the judge says you must turn over those records because it's relevant to our case, then I will, otherwise I'm in contempt. However, the judge may also turn around and say, can you just provide a general summary of what's been going on in the treatment care of this child? Okay, to which I will say absolutely, and I will provide that information. And contrary to what the attorneys may like, it's not about what they like. It's not about what they're looking for. It's not what they're trying to prove their case or not. It's to protect the client. There is one situation in which the physical or mental welfare of a child must be protected, even if the judge tells you to disclose the records. That's the Larry Abrams case. It went to the state Supreme Court back in 16 years ago now. Larry is a psychologist in the Houston area with a divorce situation with a non-custodial parent demanding copies of records because that person wanted to modify the visitation thing or the custody thing. I can't remember which one it was. And the information that Larry had is that child was being physically abused, but not to the extent that protective services would get involved. And based on that, he refused to turn over the records. The local judge in the case said, you must disclose the records. Larry said, I cannot in good conscience, nor can I, to protect my client, disclose this information without putting the child in harm's way. The judge held him in contempt. At that point, there was an appeal made by the Malpractice insurance company, who assigned an attorney to work on Larry Abrams' behalf. Appealed the contempt citation. It went up to the court. It went from circuit court to the court, finally to the state Supreme Court. And the state Supreme Court, in a very conservative makeup of state justices, unanimously agreed that the welfare of the child must be preserved at all cost, and denied that original judge's request. Okay, that became known as the Abrams Rule. That if you truly, honest to God, believe that child's life could be jeopardized by releasing those records, do not release them, and you will be supported, because there's a precedent that's already been set in Texas. It's been set in just about every state of the country now, because Larry Abrams, unbeknownst to him, became famous. And Larry's a very modest guy. I don't know if any of you know Larry Abrams, but he's a very modest guy, never wanted to get involved with this kind of nonsense, but he became a star simply because that stuff got out. And it became almost as vitally important as the Tanazoff ruling out in California, which basically said if you know that your client is about to commit a crime or about to kill somebody, you have a duty to warn all those people, whoever he may be threatening to kill. And we now know that that rule in California still applies in California, but not in the other states of the country, including Texas. You do not have a duty to warn the protective or the individual who's being threatened to be harmed. Your duty is to protect the public. So you notify the local authorities, but not the individual. That's not your job. That's a different kind of situation. But what we're talking about are records, and that becomes the critical issue. So for the most part, yes, you will disclose records if they're asked for. The statement specifies that part of the record, and it may be a case where you redact records too, where you actually black out certain statements or certain things that are in a record, and you can still provide some of the record, to a parent. That's your discretion. Your job is to protect your client, though. And if you need some help with that, I encourage you to call your malpractice insurance people. They will assign an attorney to work with you. And because you're paying for that service, you don't have to pay additional money for the attorney. You meet with the attorney, they will tell you, they'll go over the records with you. And from a legal perspective, they will tell you, this information should never be disclosed. This information should be redacted. Here's what you redact out to cover your butt legally. Or they may tell you, hey, you don't have any standing in this thing, give them the records, whatever it may be. Again, it's your clinical discretion, but it's the welfare of the child that has to be the primary issue. And your notes should already reflect that there is abuse going on. So it's not just an opinion that it might happen. There has to be an indication that it has, and it's a continuing threat issue. So if the kid's telling you, I'm afraid you're gonna beat the crap out of me if I, no, that's not sufficient. You need to know if the kid has had the crap beaten out of him, because then you're protecting the child's life. Okay. The continuing issue of the confidentiality is something that happens regardless of what those situations are. So the summary that you can provide, that you offer to them, again, you may get the request from the parent saying, can you give me a summary of what's going on with my kid? I don't have custody of him, but I'm concerned about him. I want to see, what you're doing with him. Unless that divorce decree clearly says he cannot or she cannot have access to even a narrative report, you do have a responsibility to provide it. So your response is, yes, I will get this to you as soon as I can. And keep in mind that soon as I can is a 15-day window. It's actually stipulated in 611. You have 15 days to disclose a narrative report or to turn over records if they're requested. Okay, it's not your discretion to take your time forever. It doesn't matter if you're on vacation, 15 days. It's not working days. It's not business days. It doesn't have anything to do with holidays. It's 15 days. That's black and white. Okay, if you're on vacation, you better make sure somebody has access to get those records out because you're responsible for it. Okay, and you can provide a response back. If it's something that is way beyond your ability, your office got flooded out, you have no access to those records, your stuff is not being stored in the cloud, so you can't actually bring them down somehow and get a copy available to them. Whatever that situation is, it doesn't matter. COVID doesn't get in the way of this at all. You have that obligation, and it's still 15 days. Okay, hopefully we'll get that part done, so you don't have to worry about that as an issue. The disclosure in the judicial situation is a little bit different because what we're dealing with here is usually some kind of a crime that's been committed, and that stuff does have precedence. And a lot of times we'll get into situations that a crime's been committed, your client's been accused of a crime that has nothing at all to do with what it is you're involved with. A situation where a young guy was actually picked up on a suspicion of drug possession, and I'm seeing the client for depression. There's no history of drug abuse at all. It's not on the intake sheet that I use, or didn't check off any of those boxes indicating there was a problem, but he gets arrested for drugs. I get a phone call from the prosecuting attorney, Harris County, wanting copies of my confidential records of his mental health issues. I can assure the prosecuting attorney that I have no records at all pertaining to drug use. Now, sometimes that's enough for them, and they will say, fine, don't worry about it. Sometimes they'll say, I want to look at those anyway. The dilemma you have is that, again, you're protecting your client. And part of what you may end up doing is saying, look, I would love to comply with your request. I'm giving you an honest response. I'm going to put this response in writing to you so it can be evidence that you can submit to the judge, or you can get the judge to send me a subpoena demanding release of those records. Most of the time, prosecuting attorneys will get real nasty with you. I'm going to use another word, but I won't, because they think they should have access to anything they want, and they don't, even though it's a criminal case. Now, if this case pertains to drug abuse and you are treating your client for drug abuse, now we have a whole different situation. Because in that context, your notes, your records become part of the public domain. And the discretion of not turning them over is not the same. Same thing involving any kind of abuse. If you have a client who has a past record of assault, and you get a call and you're treating that guy for anger management or that woman for anger management, and you get a call from somebody saying, hey, this guy's been arrested, this gal's been arrested, we understand they've been seeing you, we'd like to review your records. Okay, in that situation, yeah, they do have access to your records. Now, you also have the right to redact out of those records anything that does not pertain. So if they're giving you information about their sexuality issues, or in one case, I have a transgendered person that was terrified that because he had been arrested for shoplifting, that if the information became public, he was transgendered, that there could be nasty repercussions from that. So that part got redacted out. He did have a child record, and because he was still 17 years old, even though they were talking about charging him as an adult, he still had a juvenile record of shoplifting. And it happened more than once. So that part, that my knowledge of that, because the client had shared that with me, that was information that the prosecuting attorney had access to. Everything else about that client was redacted out, just to protect the client. Okay, hopefully that clears that up. There's certain things there that deal with involuntary commitments, mental health commitments. I'm not going to go into that with you right now. But if you want more information about that, 611 tells you exactly where to find that information. And it deals with different chapters. There's a chapter of 420, 462, 574, 593 that all deal with the judicial issues related to an involuntary mental health commitment. Okay. Very infrequently will most of us run into that situation. Sometimes you may if you're working for the state, or if you're working with one of the hospitals, public hospitals that do hearings or do support hearings where you're holding people for evaluation, and you're actually starting therapy with these people in a confined situation while they're being evaluated for an involuntary commitment. Okay, so for those of you that are doing that kind of work, my heart goes out to you. God bless you. It's a thankless kind of job that you're running into. However, it's a very small population base. So if you want that kind of information, take a look, because you're probably already familiar with it anyway. But you just want to be careful again, because the client, even though they're in a situation of being involuntarily committed and being evaluated for it, they still have a right to confidentiality. It's not the same as a person who's not being in consideration, but they still do have that part that's connected to them. So when you get a request from a client, a parent, or anybody wanting copies of your records, and it looks to be a good, legitimate request, you do have the right to charge money for the photocopy. Just make sure it's reasonable. You cannot charge $185 per page of a 14-page record. It must be a reasonable charge. I think the state allows for, normally, if you go for state records, they typically will charge you 25 cents a copy. I don't know if that's your time, but because that's what they figure in. It's not just the actual paper and the ink, it's also your time to do it. So you can increase the charge per page. But just make sure you let them know that this is the charge that must be paid, and you can hold the record until you get payment for it. Okay, if it's a monstrously long record that's going to take a long time to provide, keep in mind that 20 or 25 cents a page is going to add up. So if it's going to be a lengthy kind of thing, let them know. This is the fee that I charge in order to get copies of records, because it takes time to do it, not just the photocopy use and the paper and the ink and all that kind of stuff. So the fee is going to be 20, 25 cents a page, and I need to collect from you the $38 it's going to cost as a prerequisite to me releasing the record for you. You are within your right, according to Section 611, to do that. Again, though, you got 15 days to come up with the copies. So regardless of how long this thing is, you're still bound by that 15-day thing. That is most of the content of 611. Like I said, I've kind of skipped over a few of the sections that don't pertain to a lot of professional counselors or marriage and family folks. But that's typically where we're going to run into record request problems from an ethical standpoint. So let's open it up and see what other questions have come in.
Okay, Teresa Buchanan, this is more of a statement. I want to share some helpful information shared in another Texas ethics training by an attorney. She recommended having a liability insurance that would cover attorney fees to represent us with the board in the event we get a board complaint. Okay.
That's standard. If you look at your own malpractice liability plan, the policy you actually have, it almost always includes legal fees for that exact reason. And it stipulates that if you're brought up on charges, or the state wants to interview you because of a disciplinary issue, you have the right to call your malpractice folks. They will assign an attorney to work with you. It's generally a standard policy issue.
Nice. Chandra Peterson, I hope I'm saying your name right, has 2 questions. I'm in Nebraska where children are minors until 19. If they move to another state when they're 18, who owns the record? And is it 5 years for all states keeping files?
Well, okay, last part, no. Every state has the right to set up their own time limits. A lot of them have gone to 5. Texas for a long time was 7. And some other states are 10. But most of them are rolling it back to 5. There's something magical about that number, I guess, and they're looking at that. It's the same number of years that we cannot be sexually involved with our former clients. Why it's a magical number of 5, I have no earthly idea. But somebody in the state legislature thought that would be an appropriate number of years to wait before we become socially and sexually involved with our clients. I still question the discretion of that kind of judgment, but in any event, it's 5 years. And regardless of another state's requirements, the fact that you saw your client in Texas means that you are bound by the Texas law. Okay, Texas says the age of consent is 18. So if you are seeing somebody before they turn 18, it's 5 years plus the amount of time it takes for them to turn 18. And you must keep those records for that long.
Sally Howard says, for clarity, once the minor becomes an adult, what happened to it? Hold on, it moved. Once the minor becomes an adult, parents do not have access to the children's records anymore. Is that correct? Unless the child, now adult, gives consent, correct?
Correct. Yes. Adults have full power over their records, regardless of when the service was provided. Once they turn 18, they're the ones who make the call, unless the parent has guardianship. And in some cases that happens. We've got a couple of folks that are in the bottom end of the autism spectrum, and the custodialship guardianship is extending out beyond the age of 18. So those parents would still have control over the records.
Yurid Salazar, is this only when there's a divorce proceeding?
For what?
I have no idea. That's the only. I'm assuming it was
access to
being
records.
Asked while you were speaking of something. So.
Exactly. If there is no divorce and the parents may be separated or they may be together, either parent can request access to the records.
I don't know. I personally am so happy to be divorced. I carry my divorce decree on my cell phone so I can show it to everyone.
I fail to see why that would be a bad thought, honestly. Just in case. Just in case. Especially if you have
Nobody
kids.
here knows my ex-husband. Okay, moving on. Brittany Darden wants to know, what about instances in which parents were never married and have no official parental agreement?
Great question. The parent who is wanting access to the records has to prove that they are the biological parent in order to get those records. It's not a situation where you can just come up to a counselor and say, I'm the father of, we never got married, and I don't have a birth certificate that shows that I'm actually identified as the father, but I want records to this kid. And no, it doesn't happen like that. There must be proof that you are, in fact, the biological parent. And if you can provide that, that's fine. It could be a birth certificate if it lists both parents on the certificate. Although I am more and more becoming aware that a lot of situations where unmarried women give birth to kids, and they will list unknown as the father, even though they know who the father is, because they're trying to keep the father out of legal complications, because the state will go after those people for support.
That is true. In Texas, when my child was born, the child I had a different last name than my husband.
Mhm.
And so the child's name was baby, my name, and not
Right.
his.
Yeah, quite often.
That's very true.
Yeah. So yeah, it's just one of those cautionary things. But yeah, there are a lot of kids that are born out of a married situation. And there's no adoption records of, that have gone on, which is the other proof that you would have. If the parent comes in with an adoption, hearing thing that says you're the adopted parent, legal parent now, then yeah, you have right to the records.
Chandra Peterson, just to make sure, a non-custodial parent can have access to records. What if the custodial parent is involved in the session?
If both parents are attending a session involving the child, the release of the record would pertain to that parent that actually has custody. Now, that's different than reviewing the records or getting copies of records. That would allow both parents to be involved in the session. Okay, that's different than accessing records. So if both parents are wanting to have a conference with you as the counselor because you have concerns about what's going on with the kid, and the custodial parent invites the non-custodial parent to be there and they're co-parenting in an effective way, yeah, the fact that the parent who has custody has invited the other parent in, that is confidentiality release. They're there in person. So yeah, you don't need anything beyond that. Now, it may be a different situation, however, if the non-custodial parent then wants to bring the kid in on his own or her own without the custodial parent being present, then you would need the authorization from the custodial parent that that's okay. And it should be in the divorce decree, stipulating it that way also.
This is a statement from Sally Howard. Many probation officers are not licensed counselors. In regard to questions asked previously, if the probation officer is acting in the scope of counseling, is it really counseling, thus their discussions confidential? Or is they seen as probation notes only, therefore not confidential? Most criminal justice state agencies in Texas note that all contact with probationers or incarcerated persons by caseworkers, social workers, psychologists are property of the agency and the probationer/inmate's file. Thus, it might be frowned upon or even seen as an agency violation to keep a separate file on counseling notes.
Mm-hmm. It could be, but I've never seen it taken that way. Okay. Now, is it possible that you might have a specific situation where a jurisdiction of probation is saying that if you're going to see your client, regardless of the fact that you're a licensed mental health person, any records have to belong to the state? I've never seen that enforced or requested, actually. Now, what I have seen more often than not is the first part of what this person was just talking about. As a PO, if you are not licensed as a mental health provider, everything that you discuss with that client is part of your job as a PO. Even if it's just trying to be a nice person, and giving them some counseling advice, you're not acting as a professional counselor. Therefore, all of that information is part of the PO record. Okay. It's a different situation, though, if you are licensed as a mental health provider, because then the confidentiality has to be enforced.
That's interesting.
Mm-hmm.
Roy Garcia said, is it a violation of confidentiality to acknowledge that your client is your client if records are requested by anyone?
Yes, it is.
Janie Lopez, in contract work situations, what if the contract company releases the records when they receive the request from the client? What do you suggest?
Making sure your malpractice insurance is current. Yeah, again, when you're in a contract situation, you're the odd person out. Okay, the person that's coming in for the service is coming to the agency for that service. The agency is basically paying you to provide the service on a contracted basis, but the service you are providing is confidential to the client. So the client's relationship with you is that you're providing a service. However, the client is not yours. The client belongs to the agency. The agency keeps the records. The agency is responsible for following Chapter 611, as well as any other rules that pertain to the safeguarding of confidential records. Okay, that's not something you're involved with.
Okay, this is a good one because we get this at IntraCare all the time. Students and their parents prefer texting documents and information. What are your thoughts about that?
Well, it's not preference. If they insist on doing it after you tell them that it's not protected, I would have them sign a waiver that stipulates that they are aware that by sending this confidential information by email waives their right to confidentiality. And in the event it gets disclosed in any capacity, they will not hold you responsible for its release.
Okay. My boss never lets us text anything with
For good reason. For good reason.
Yes, we're very by the book. So since it's 11:01, did you want to finish answering these, answer them on your own?
Well, let me give you my contact information. So if folks want to reach out to me, I'm more than glad to answer questions, talk to people. I love talking to people, as you probably have already gathered from the last 2 hours. I talk. So yeah, to reach me, my email address is, what's my email? It's Doc Marty, DOC MARTY at Allied Mental Health TX for Texas.com. Doc Marty, DOC MARTY at Allied Mental Health TX.com. Yeah, Suzy, thanks.
I went ahead and typed it in for everybody.
That's the email. Phone number, if you want to reach me by phone, the office line is 281-812-3322.
There we go. Okay, so Eric wants everyone to know, thank you for joining the webinar. You will get a link at the end of the evaluation to do your evaluation, and you can print your certificate of completion, and there'll be a follow email tomorrow. And we're so excited, and thank you for this wonderful presentation. It was so informative. I loved it. I'm sure everyone really took a lot out of it.
Thank you, Suzy. I appreciate it. Thank you all for listening. This is not a fun topic usually to talk about. So for those of you who have been with us for 2 hours, God bless you. I wish you a great weekend. And hopefully you've now got the 2 credits, and you got one more to go for your 2-year requirement for the jurisprudence thing, which is always a joy to do. And I'll take care of the stuff for you. So if you have questions, by all means, let me know. I'm more than glad to answer those things that come along.
Great.
Thanks
Thank you, Dr. Lerman. And Suzy, you make a great talk show host. So look forward to do it again soon. Y'all have a great weekend. That concludes our webinar for today.
Thanks, everybody.